Hello guys, welcome back to my YouTube channel. It's Mihala Barasa and today I am going to be highlighting something fresh off the judiciary kitchen. This is a decision by the Honorable Justice David Majanja, who sits in the Commercial and Tax Division in Milimani. And it is very important for you to remember that this is a judge of the Commercial and Tax Division because it is very integral to what we are going to discuss today. So I recently came across this tweet. I really like Twitter. It informs a lot that I come to discuss here. So I recently came across this tweet, and the guy was talking about, the advocate was talking about this judgment by the Honorable Justice Majanja that So I recently came across this tweet, and I love Twitter because it informs quite a bit of what I come to discuss here. And there was this tweet by an advocate, I can't quite remember his name, but I'm going to find the tweet and I'll put it here or in the link in the description box. And the advocate was talking about a judgment given by the Honorable Justice Majanja very recently. And this judgment was to the effect that the Small Claims Court, which is one of our favorite courts because of the timelines, that the Small Claims Court cannot hear and determine disagreements and disputes relating to people owing you rent money. And I thought this is an important decision to come and discuss on the channel because some of us are landlords, some of us are tenants. Kama umepelekwa Small Claims Court, this is your time to look for this decision and shine. If you're a landlord and you want to take someone to the Small Claims Court, this is the time to reconsider. So the decision was given on the 18th of October 2022, and the decision is by the Honorable Justice David Majanja, like I said, and the citation is Milimani High Court Civil Appeal number 36 of 2022. Milimani High Court Civil Appeal number 36 of 2022. And it is called an appeal because it was an appeal from the Small Claims Court going into the High Court. Mpaka I hope we are together. And the parties to the case are a lady called Lisa Christine Christopherson and Kavnit Kaur Sermi, who trades as the Random Shop. And this was an appeal from the judgment and decree of the Small Claims Court given on the 25th of February 2022, just a day after my birthday, and by an adjudicator of the Small Claims Court called BJ Offici, resident magistrate or adjudicator. So what's the story? Let me start by telling you the story. So this is the story. So this lady gives out her house to a tenant to rent, and the rent amount is 150,000. The lady that is being given the house does not pay rent for 6 months. The rent accrues to 900,000, and then they never have anything written. It's a verbal agreement. And at some point, when the lady is about to move out, the landlord goes, you owe me 1 million Kenya shillings, and the other lady admits on WhatsApp. I don't have the gist of what that WhatsApp conversation says, but from my reading of the judgment, the tenant actually admitted in the messages that she owed the landlord 1 million shillings. What does the landlord do? Goes and becomes the claimant in the Small Claims Court, tells the Small Claims Court, look, this person came to my house, they lived for a period of 6 months, they owe me 1 million bob now, they've never paid me, please help me. What does the Small Claims Court do? The Small Claims Court says, you know what, even that correspondence between you and your tenant doesn't show that there was actually an enforceable agreement between you two, so obviously you're taking an L. This lady is like, nah, there's no way I'm taking an L. We are going to the High Court to appeal. Hence the decision of Justice Majanja. And please remember, when we started this conversation, when I started talking about this analysis, I said Justice Majanja is a judge in the Honorable Justice Majanja is a judge in the Commercial and Tax Division of the High Court. So Majanja goes through the judgment and the appeal papers, that's also called the Memorandum of Appeal, that has been filed before him, and the response. And Majanja is shocked. He's like, you guys, these people, what they were beefing about is a rent dispute. And a rent dispute is not supposed to be adjudicated in the small claims court to begin with. This is something that should not even have gone to the small claims court at first instance. Both of you advocates missed it. The advocates for the claimant missed it, the advocates for the respondent missed it, and the adjudicator missed it. And he goes ahead, he goes ahead to talk about the one thing that lawyers like talking about, jurisdiction, the case of Lillian S. He goes about to say the jurisdiction of the small claims court is limited. And what cases can the small claims court hear? The ones that I know over the top of my head is a contract for sale of goods or services. Number two, if you get a personal injury, and with this I mean like accident cases, as long as they are below 1 million, personal injury claims, you can take them to small claims court. Money owed, and you have a contract with someone, whether verbal or written, and they owe you some money that they received or you gave to them, again you can go to the small claims court. There are things called set-offs and counterclaims that can also be brought to the small claims court. Oh, and the last one is if there's damage caused to your property, movable property, again you can go to the small claims court as long as you can quantify this under $1 million bob. So I'm sure Majanja goes like, the Honorable Justice Majanja goes like, okay, so section 12 of the small claims court puts this as the things that the small claims court can handle. There is no rent dispute here, there is no landlord-tenant dispute here, there is no recoveries for money of rent here. And he goes on to say, you know what, you filed in the wrong case, you filed in the wrong court in first instance, and even on appeal, you still came to the wrong court. Why? Because even in the instance of this appeal, and in the instance of that case, the first case for the rent dispute, it's a dispute that should have gone to the environmental and land court. So for that reason, he decided, you know what, I'm striking out this case, I'm throwing it out. So I feel like the respondent in this case was a very, very, very lucky person. The person that this tenant, the God that this tenant prays to, the person that this tenant prays to, the universe that this tenant prays to, made them very, very lucky, because I'm sure the judge looked at the case and thought, this is not something that should have been handled by even the small claims court at first instance, or myself from the commercial and tax division of the High Court. It should have gone to the environmental and land court. And I feel like this is an interesting learning curve for landlords and tenants, and I'm sure also for employment cases. I don't know if the small claims court is now handling employment cases, but if there is a case for salary arrears in that court, I am sure if there is no judgment like this, one of them is probably looming somewhere, lacking somewhere. If there's anyone suing someone for child maintenance in the small claims court, again, a judgment like this is coming somewhere, it's coming. But I'm so glad like I stumbled on this tweet and on this information. It has been very insightful. Like I did not think that landlords are going to be sent to the environment and land court unless the Small Claims Court Act is repealed or it's amended for it to include issues to deal with land and rates and rent. These cases will continue to be referred to the Environment and Land Court. This was so interesting. This was short, but it was sweet. Thank you for hanging out with me. Thank you for being here. I'm going to put the judgment down in the description box for you to go and read and see. And until I see you next time, it's Mihala Barasa. Bye.